Everyone. Welcome to our third webinar of our 5-part privacy webinar series. So you thought you knew health privacy. Today is part 3, like I mentioned. Today we're going to be talking about the new sheriff in town, the groundbreaking emergence of the FTC in privacy enforcement. What have they been doing in the past few years? What are they doing now? And what do we predict for the future? Before we dive in, just a few really quick disclaimers. Attending and listening to this webinar does not make you a Nelson Hardiman client. This webinar is provided for educational purposes only and is not offered as and should not be relied upon as legal advice. Although this specific webinar is not going to be California centric, the next one will be, and a couple of the previous ones were. We live in California, we practice in California, so if some of the information is California specific, we apologize to non-Californians. And if you're considering what to do with the information presented in this webinar, please consult an attorney for any specific situations. We at Nelson Hardiman are definitely eager and ready to help, but of course, no obligation there. My name is Adella Katz. I'm an attorney at Nelson Hardiman, and speaking with me is our fabulous managing partner, Harry Nelson. And we're ready to dive in.
Let's do it.
So a very brief agenda about what we're going to be discussing today. There's a huge expanding gap in health privacy regulation. We've been talking about the HIPAA and high tech for so many years, but the FTC has actually tried to carve its own niche in health privacy regulation in the last couple of decades or so. It's been silent for a long time, but very recently we've seen a huge emergence of action by the FTC. So first, we're going to talk about a little bit of context and a little bit of history before we dive into the really interesting core of this webinar. What are the enforcement mechanisms in the FTC Act that they're using right now to regulate health privacy? We're going to return back to our zoo of healthcare privacy that we talked about all the way in our first webinar. What have the changes been in the last few years? What has the catalyst been for the FTC's emergence into healthcare privacy? We're going to review a few really recent, really imperative cases, kind of talk about the consequences of unregulated selling and sharing of sensitive healthcare information. Then we're going to understand the changes that are on the horizon. How is the FTC going to tackle growing technology with new categories of health information? What is the FTC going to jump into next? And then we're going to end off with a couple of important takeaways.
So we wanted to come back to this graphic, which we've used on our previous webinars, of what we're calling the zoo of healthcare privacy. And the point here is to emphasize that really over the last almost 50 years, we have been watching an unfolding journey of evolving expectations and requirements around both federal and state health privacy laws. And so, the important thing to note for the purpose of this webinar is that if you look at the period from 1975 until roughly 2022, you really do not see much activity of any kind from the FTC or the Federal Trade Commission, which is our focus today. And the reason for that is not that health privacy and health data wasn't within the purview of the FTC, but really that the FTC did not show any signs that we can see before the 2020s that this was a priority for them. And then all of a sudden, what we have in the last few years is a radically changing world where the FTC seems to be front and center, as the title of our webinar alludes, really a totally different world on health privacy. And as we're going to talk about, tackling health privacy in a way that isn't just relevant to traditional healthcare, but to any technology company out there that is touching in any way, any consumer company also touching health data in any way. So really a new and different, and that's why if you look at our slide, you'll see all this activity and call outs on the far right. This is really an evolving story that's really hot off the presses. So we want to really focus in on kind of this today is going to get much more into the detail of what's the law and what's the recent activity and what should you take away from it. But as a starting point, the first question is why that all of a sudden in the 2020s, we have this awareness of a gap in health privacy that caused the FTC to step in. One subject that was the subject that really the focus of our last webinar is kind of a growing awareness of the limited reach of HIPAA. We encourage everyone who didn't watch it to go back and watch our last webinar, which talked about what a landmark HIPAA was in creating a framework for traditional healthcare, but where its limitations come up when it comes to the real activity and sources of health data, right? Sources like geolocation, search engine, input, and voluntarily submitted information, all things that aren't covered by HIPAA, as well as just the limited, the limited goals that HIPAA set and is achieving that are away from where the action in health privacy is today. One of the sources of awareness, apart from HIPAA more broadly, is just that all the technology we interact with, I never have my smartphone very far away from me, and we are all just constantly inputting our own health data in, right? Sometimes now, if you're using the latest behavioral health apps, you're actually inputting your information for a bot or for some AI technology, but we are all, the technology is basically a sponge into which all of our health data is going. And so there's that issue. More broadly, there's been this whole concern, even apart from healthcare, about big tech. What's going on with Facebook? What's going on with Google? All of these big social media and digital companies, and the way that we are all developing a so-called digital health footprint that can be used often in ways that we didn't intend, right? I might be an employee looking for a job, and my employer can gather information about my healthcare. I might be a candidate for disability or health insurance, right? So there's the general concern about big tech that has led to this. There's clearly a dimension upon which the repeal of Roe v. Wade and reproductive health access has made health privacy a cornerstone priority for the current administration and a topic in everyone's awareness, and we're going to talk about that. And finally, the last thing to say here, just sort of to explain everything, is that in many ways we've been waking up as a country to the extent to which our privacy is not as optimally protected, and to the way in which our privacy laws have been a little bit outdated, and that corresponds to a change in Europe earlier around GDPR that you can see echoed in all the state laws that follow the CCPA, the California Consumer Privacy Act. And it's really like, you can think of it in tandem as a federal and state move to address a sort of a gap, or a lot of gaps, that we're just waking up to.
Shifting gears just a little bit before we dive into these really interesting cases, and before we talk about the huge impact of the Dobbs decision that Harry was just mentioning, we wanted to provide a brief history of the FTC Act in general, what its original purpose was, the intent for it, and how it's evolved to kind of step foot into the realm of healthcare privacy. So the Federal Trade Commission and the FTC Act was actually created more than 100 years ago in 1914. Its purpose was to prevent essentially monopolistic activities, monopolistic endeavors by big companies that were trying to reduce competition in the marketplace, essentially reduce consumer choice. Shifting into the 1930s, Congress passed broad prohibitions against unfair and deceptive acts or practices, which was a super general statement, but essentially tried to expand the reach of the FTC into different kinds of industries to really protect consumers' rights against companies being unfair or deceptive to them, again, and reducing their choice and reducing competition in the market. Only in the 1970s did we see the FTC actually focus its sights on the monopolization of the healthcare industry, with huge mergers that we saw with insurance companies, pharmaceutical companies, even hospitals, which of course has extended into today, but in the 70s is when we first saw that change. And really only in the last couple decades, especially after the passage of HIPAA in 1996, did we see the FTC express concerns about the growth of healthcare technology, especially in the last 15, 20 years, which resulted, of course, as we talked about in our previous webinar, in the passage of the Health Breach Notification Rule in 2009, which was exactly the same year that the HIPAA Breach Notification Rule was passed through the HITECH Act. So what are the enforcement mechanisms that the FTC uses to actually enforce anything against these direct-to-consumer healthcare companies, right? Because as we talked about previously, HIPAA only applies to a really narrow universe of healthcare entities. So any kind of app that we're talking about, any Apple devices, Samsung Health, FloHealth, GoodRX, BetterHelp, companies that we've seen in the news that provide healthcare services, they're actually not covered entities. They're not business associates, so they actually really fly under the radar, the HIPAA radar. And so they're actually subject to some kind of regulation, some kind of enforcement by the FTC. So Section 5 of the FTC Act was originally passed way back in 1914 and has evolved to be used by the FTC against healthcare companies to protect consumers, again, against unfair, deceptive acts or practices that affect commerce. The statement hasn't really been changed in over 100 years and is super generalized. There are certain elements that the FTC has prescribed under each of these unfairness and deception buckets, which I've listed here for you in the table. But essentially, we're looking at anything a company does, and right, the focus now is on company's website. So anything that a company promises publicly to its consumers that causes consumers substantial injury, that can't be reasonably avoided by consumers and is not outweighed by countervailing benefits to consumers. So essentially, we're looking at anything that a company does on its website through its privacy policy, right? That's what we're seeing a lot in these new cases that we're going to talk about in a few minutes, that all these companies are promising to consumers, we're not going to sell your information. We're not going to share the very, very sensitive health information that you're inputting into our websites. We're going to keep it protected, and we're going to definitely seek consent from you before we do anything. Obviously, that hasn't been happening, and that's why we've seen these huge lawsuits in the news. So the FTC has been using Section 5 pretty heavily. But also, in addition to Section 5 of the FTC Act, as I just mentioned a second ago, in 2009, the FTC actually passed, in the same congressional act as the HIPAA breach notification rule, the FTC passed its own health breach notification rule that specifically targets these direct-to-consumer healthcare companies. They called it the health breach notification rule. It's been sitting dormant since 2009. It's never been wielded before until really just in the last couple of years. Just a couple of weeks ago, actually, in the PreMom case, which we'll talk about in a few minutes, we saw actually the second use of the health breach notification rule ever in history. Yeah.
So just to a couple comments here, I just want to
Sure.
say, if you're watching this, first of all, just for fellow healthcare lawyers, health privacy lawyers who may be watching, I just want to make a true confession. In practicing over the last 25 years in this area, I always, whenever you say FTC, my mind as a healthcare lawyer goes in two directions. Number one, is there an antitrust question that we have to address here about some kind of unfair consumer behavior? And number two, is there something misleading that we're saying? And my mind almost instinctively would go to, like, let's look at that. When people would say FTC, we'd say, is the communication clear?
Mm-hmm.
Is there any problem here? What we're talking about is really a revolution. And I can tell you that even a few years ago, we don't have to go back very far, we would be in regulatory due diligence for companies that were going public and underwriters wanted to make sure they were in compliance or being publicly acquired or going through a private equity discussion. And there would be healthcare lawyers on both sides that would not be talking about these issues. So whether you're listening as someone who's in a business that may be subject to this, or as an outside lawyer, it is really, truly a whole new game. And those conversations are very different today than they were. And it means we all need to be really doing our work to get in front of these laws.
Definitely. And that leads me to say that any kind of direct-to-consumer healthcare website, healthcare app developers have to be cognizant of FTC enforcement now under Section 5 and under the health breach notification rule, because clearly the FTC is now wielding that sword, which they've never done before. Let's talk a little bit about the health breach notification rule in detail. Why did the FTC implement it in the first place? As we talked about, the growth of new healthcare technologies really in the last 15 years or so. I think maybe put a little fear into their hearts, recognizing that these lay people, essentially these business people, want to provide healthcare services and know they're not going to be subject to the HIPAA privacy rule, security rule, breach notification obligations. They wanted to create some kind of mechanism to hold these direct-to-consumer healthcare companies accountable. And in a recent policy statement, I've inserted a little snippet into this slide. The FTC is definitely recognizing that it wants to keep up the pace with changing technology. We'll talk a little bit later on, but just a couple of weeks ago, they actually released proposed changes to the health breach notification rule, which probably will go into effect later this year. Again, trying to adapt to new technologies and expanding certain definitions and breaking apart certain terms to make sure they encapsulate new changes that are happening today.
By the way, just to make a point for anyone who's listening who has a healthcare company or a consumer company, you probably are going to need to take a look not only at your privacy policy if you haven't done so recently about this, But what Adella is saying, this new rule coming is going to mean a change for everybody. So privacy policies, which used to be these sleepy paragraphs that would live on people's websites or apps, are now a major place of attention. And as we'll talk about, a place of risk, not only from the government, but for all kinds of potential plaintiffs.
Definitely. And that's because all of these companies who have been flying under the HIPAA radar are actually considered vendors of personal healthcare records under the FTC's health breach notification rule, as opposed to covered entities or business associates. I'm sure everybody's heard of those terms. We talked about it extensively in our previous webinar. But anyway, it's important to know that any of these direct-to-consumer healthcare companies, because they're collecting health information from consumers from multiple sources, any kind of browsing or tracking activity, any search terms on a website, any kind of information that the consumer's inputting into their password protected account, even the contact us page to seek more information, all of that identifying information related to seeking healthcare services is all collected in what we call personal health, collected by these vendors of personal healthcare records. So vendors of personal healthcare records and any related entities that provide services for those vendors. So any kind of advertising or analytics entities that provide services for them are also subject to the health breach notification rule. This is, we can analogize this to covered entities and business associates under HIPAA, which, like I mentioned, are not specifically covered by the FTC's health breach notification rule. But it's important to understand that comparison because, again, the health breach notification rule was passed at the same exact time as the HIPAA breach notification rule. So a lot of the terms, even though they're different, they share the same intent, and the breach notification obligations are actually very, very similar. So I just went over a few of these key definitions, but essentially any identifiable information from consumers that's related to healthcare information or seeking healthcare services is considered PHR, identifiable health information. It's placed into this electronic personal healthcare record that's kept by vendors of personal healthcare records or any related entity that provides services for them. So as we just discussed, practically speaking, the health breach notification rule really applies to makers of healthcare apps, connected devices, digital therapeutic products, any kind of website that's selling healthcare products on the web, anything like that, or even weight loss products, even all those fitness apps that everybody uses to track their steps, anything like that, your Apple Watch, etc. So the breach notification obligations under the FTC's health breach notification rule are very similar to HIPAA's regarding how to notify consumers when there's been a breach, oops, sorry about that. Since under HIPAA, companies have to report breaches, which include, by the way, not just anything heinous, right? Not thefts, not specifically hacking, but any unauthorized sharing or selling of information, which is the problem that's happening today. So under HIPAA, these covered entities and business associates will report to the Office for Civil Rights, but under the health breach notification rule, since it's governed by the FTC, there's a different reporting mechanism, but essentially the function is the same. What's really, really important and what we wanted to stop and take a moment to explain is that there are lay direct-to-consumer healthcare companies and especially related entities which provide services for those vendors of personal healthcare records that can actually be subject to both HIPAA and the FTC at the same time. The FTC has released substantial guidance about and FAQs about how entities are subject to one or the other and or both. But we're seeing, even though we haven't seen real cases about this yet, we're probably going to see this in the near future. If you have an analytics or an advertising company, even a social media company, right? Facebook and Google are getting into hot water all the time. They can be subject to both breach notification obligations under HIPAA and under the FTC by sheer fact that they're providing services to covered entities and these direct-to-consumer healthcare companies.
Right. I just want to add, we're going to talk about later in the webinar the extent to which companies are getting, healthcare organizations are getting surprised by
Right.
dual sets of obligations. This is a really, really important point to stop at. You may think that you're only subject, maybe you thought you weren't subject to either. Hopefully this webinar is waking you up that everybody is covered, almost everybody's covered by the FTC responsibilities, but it's very important to figure out if you are indirectly also subject to HIPAA through your contracted relationships, and people sign business associate agreements like without thinking about it, and they have profound implications here. So very, very important follow-up item for any company dealing as a consumer company or a healthcare company.
Definitely. And as we just discussed a minute ago, there are definitely upcoming changes on the horizon to the health breach notification rule. There were proposed changes released just a few weeks ago in mid-May of this year. There's a 60-day comment period in which the public is allowed to comment. So after that, we'll probably see any changes implemented later this year. The changes effectively are trying to broaden the scope of certain terms, trying to break down, who are vendors of personal healthcare records, really? Who are these related entities, these business associates under the FTC who can be subject to both HIPAA and the FTC? What does a breach look like?
What seems clear is that the FTC is clearly bothered by the activity going on out there. We're going to talk about the enforcement actions in just a minute, but it's only just a drop in the bucket, and they are really trying to change the rules to sort of really slap the industries, consumer industry, the healthcare industry over the head with what their responsibilities are. So I think you can read both the enforcement actions and the changes in the rules, this next one and the ones to come, as part of this bug that the FTC has, that the industry is not dealing with this issue seriously enough yet.
Definitely.
So we're back. This is our return slide, and you can see we're going to start talking about the enforcement activity, and it really begins. The critical part to look at here is the actually preceding the Dobbs case. We have the January 2021 FTC settlement with FloHealth. That was the wake-up call. That was really the first health privacy-focused enforcement action by the FTC. And then you have, following the repeal of Roe v. Wade's in May of 2022, you have the Kochava case we'll talk about, the GoodRX case, BetterHelp case, and the recent settlement just last month with PreMom. So all right, so we're really, this is the cutting edge of health privacy. So let's talk about these cases. The first one, FloHealth, is interesting. Again, 2021, this predated the repeal of Roe v. Wade, but it certainly did not predate this rising concern about abortion rights, reproductive health access that was already brewing as the Supreme Court, the mix of justices was changing, and there was worry that turned out to be well-founded on the part of people advocating for continued reproductive health access. So the FloHealth case, FloHealth was an app for period tracking, and essentially the FTC alleged that despite promising to keep data private, in fact, the app was sharing data that women were inputting to the app with Google and Facebook, right? And we talked about this a little bit on our first webinar. The issue is, for a company in the position of FloHealth, the issue is always, how do we find more people like our current users? And what better way to do that than to give the data of our current users to the Facebooks and the Googles and the TikToks and let them give us back information. And of course, we then get into this vicious cycle where the Facebooks and Googles of the world say, this person's using a FloHealth. What else might they be interested in that we could advertise to them and sell to them? So there was this kind of unholy trading. In any event, FloHealth is now required under the settlement that was reached to obtain affirmative consent from users for the way that its app shares data, and it's also required to notify users about the disclosure and instruct third parties what to do with that data, including to destroy that data. And the settlement barred FloHealth from misrepresenting the purposes for which it was collecting information, right? And we're going to talk more about that. How much consumers can control these uses, and what its compliance was with all the various privacy, security requirements, and how it continues to acquire, collect, maintain, use, disclose, delete, and protect data. And by the way, we're going to talk about this these notifications are very important, although they're only the beginning of really rethinking consumer privacy. But this was really a sort of first shot across the bow that the FTC was going to be policing this issue. So following the 2021 decision, about 6 months later, we had the repeal of Roe v. Wade in the Dobbs case. And of course, this was sort of a realization of the concern that drove FloHealth. And I don't think it's a mistake that it was a period tracker app rather than a fitness app or a behavioral health app that was the first case the FTC focused on. But that became even more real with the repeal of Roe v. Wade and the threats, both from some states that were hostile to abortion and also from third-party stakeholder groups looking to police, that were talking about going after doctors, going after women who were seeking information or actually trying to terminate pregnancies. And so this data, all this data that's out there, being able to geolocate someone based on where they were and prove what healthcare they sought, being able to find out what they were searching for on various websites, right? That became a real threat. And that led us to our second enforcement case, which was the Kochava case. Now, Kochava, very interesting, not a provider, a direct provider of information. It was really a broker of geolocation data, right? So Kochava is one of these many companies kind of in the shadows, if you will, sort of looking for geolocation data that various people are picking up. You have your smartphone and mine have allow us to be tracked unless we turn it off, where we are. And from that, people can see where we're shopping and where we're seeking healthcare. And so the FTC sued Kochava just 2 months after the Dobbs decision for selling geolocation data. And the lawsuit specifically mentioned reproductive health clinics as a place that people could visit, as well as domestic violence shelters and addiction recovery, right? It wasn't just about reproductive health, although it began with that. And the FTC alleged that basically what Kochava was selling was allowing people to who would use information wrongfully to invade health privacy and enabling people to be stalked, right? That was the domestic violence issue, allowing people to potentially have their employers evaluate them and potentially, and obviously to lose privacy on addiction or behavioral health. So the lawsuit was intended to stop Kochava from doing this. Kochava wasn't the only company doing it, but that was where the case began. Last month, as we turn to the right side of the slide, a federal judge dismissed the FTC's lawsuit, saying that the FTC regulators had not provided sufficient evidence to back up their claims that Kochava was unfairly selling information, but it did give the FTC an opportunity to strengthen its argument if it's intending to proceed with the case. So again, a really interesting case because it was it should have been a wake-up call about the risk of geolocated data, both for providers, for consumers and patients, and even for third parties whose businesses depend on this kind of data.
Yeah, I want to make a quick comment. Obviously, the FTC was using its enforcement mechanism, Section 5 of the FTC Act, like we talked about earlier, to hit Kochava with claims of unfairness and deceptive activities towards consumers by basically selling and sharing all this information without seeking their consent, especially this very, very sensitive information that tracks where they were going to seek sensitive healthcare services. I think it was a really missed opportunity for the courts this time. I think the courts have gone on much less to essentially prove that there was going to be substantial potential harm instead of just relying on actual substantial injury proved in order to stop a company from continuing with these practices. So I think the FTC might gather more evidence against Kochava and bring it back to court to ensure that they stop these activities. But we wanted to highlight this case to show that this is one of probably many companies behind the scenes, analytics companies, advertising companies, all kinds of data brokers that are collecting sensitive information and selling it and sharing it right under our noses.
Okay, so we have GoodRX. By the way, so we're going to talk. GoodRX was the first ever, as Adella was referencing, first ever FTC enforcement action using the health breach notification rule. By the way, we'll talk about PreMom, which was the second. So we are really living through history on this issue. As far as health privacy is concerned, these are just earth-shaking cases, and we can't overstate how important they were. So GoodRX was the first, and as GoodRX, many people know, was an application that was intended to address, originally intended to address information to help consumers manage their spending on pharmaceuticals. It expanded into telemedicine through acquisition, and it was a much broader set of related healthcare enterprises. In any event, in February, the FTC, brought this enforcement action, claiming that GoodRx violated the FTC Act by sharing personal health information with advertisers, with the Googles and Facebooks and so on, contrary to its own privacy promises, and that failed to report these unauthorized disclosures as required by the health breach notification rule. So a very important case to look at, right? It used, again, as we discussed, personal health information to target users with ads. It failed to limit third-party use of personal health information, i.e. the Googles and Facebooks and so on. It misrepresented its compliance with HIPAA, and it failed to implement policies to protect information. It was hit with a $1.5 million penalty. Many observers commented that that was really too low of a penalty to make a real impression. And it's interesting to wonder whether we will see higher penalties and greater authorization of the FTC to impose penalties, along with GoodRx being prohibited from sharing user health data with third parties for advertising purposes. And this was, by the way, I should say, when we saw the GoodRx case, we also saw the Facebooks and Googles reevaluating their policies, and Facebook actually closing the pixel because of its own exposure on the other end of this of these transactions. So this was a really critical case, and one that we're going to be. These are certainly not the last actions, but a lot to mine out here of lessons for everybody who's touching healthcare privacy.
Definitely.
So right on the heels of GoodRx, we had BetterHelp, right, a behavioral health company. Again, I think not a mistake that we saw behavioral health as a sort of second focal point away after reproductive health. And in this case, during its sign up, BetterHelp promised consumers that, again, that it wouldn't use their data except for these very limited purposes, like getting them behavioral health counseling. And despite the fact that it was only supposed to be using that information in the ways that it said, sure enough, going to Snapchat, Facebook, Google, Pinterest, and without disclosing it to consumers. And so, again, misrepresenting what it was doing in its own privacy policies and its own statements, failing to disclose to consumers, and failing to put any limits on how that information could be used. So ironically, when you look at all of these cases, the question is really whether Facebook and Google are really the worst offenders in terms of gathering your health footprint. It would be fascinating to find out how much they could tell each of us about our health needs. Really challenging. By the way, a subject of how much you put your own information on when you use these apps. Anyway, there was a $7.8 million civil penalty here requiring BetterHelp to return funds to people whose information was compromised, banning BetterHelp from sharing consumer health data, including sensitive information about mental health challenges with advertisers, and banning BetterHelp from sharing consumer information with other third parties for retargeting, right? So I mentioned the looking for lookalikes, but also what we're seeing here is that these companies are using it to customers for repeat visits, for retention, including people who thought about using the site and didn't, right? Trying to get those almost customers. So really interesting just to see how much activity is coming out of the FTC. And then finally, we come to the hottest case off the presses, which was literally last month. PreMom, this was the second enforcement action using the health breach notification rule. Again, sharing information here about reproductive health, not a mistake, that this has been a target area, a priority area. And again, they were sharing details with third parties about users, which led to unauthorized disclosures about people's sexual health, reproductive health, parental status, pregnancy status, physical health conditions. And in the words of the FTC, PreMom deceived users by disclosing sensitive and identifiable information to marketing firms and Google by integrating each company's own software development kit, right? Another kind of hidden trap, which these SDKs, software development kits, track user interactions across the web. In this case, $100,000 civil penalty. Again, the money isn't really the point of these cases, but obligations to not share user data anymore, require user consent before sharing data, requiring user data to only be retained and maintained for as long as necessary, and then to be deleted, and requiring a consumer notice to explain the FTC's allegations and the settlement in this case. So, there are a number of important potential consequences of disclosing information. We've alluded to some of them, right? As we've said, reproductive health is a major issue here. Increased risk of surveillance of women exercising their reproductive rights, and we haven't seen the case yet that relied upon a period tracker, but these are all sort of breadcrumbs, if you will, that could lead a government entity or a third party that wanted to accuse women of seeking to terminate a pregnancy, through that digital footprint. We have authoritative action in states prohibiting abortion rights, imposing fines and criminal liability for providers and patients.
Can I make a comment?
Yeah, please.
So what we saw after the overturning of Dobbs actually is that these data brokers, kind of like Kochava, they were actually selling and sharing information to social media sites, which either directly or indirectly were getting into the hands of authorities and or people who saw this information and reported these people who were seeking reproductive health, reproductive medications, even online. They reported them to the authorities. Actually, action was being taken against these poor people. So we've seen it before. We're definitely going to see it again. Severely prohibit or restrict abortion rights. So we don't know what we're going to see in the future, but it's definitely a concern about disclosing highly sensitive information, whether it has to do with reproductive rights or not.
Right. But by the way, a very important point to say that a lot of people look at this issue and may say, oh, is the state of Texas really going to go after this data? The real question to me is not whether the state of Texas will, but it's whether the Freedom Caucus will, right? When we saw post Dobbs, one of the first things that we saw was the Freedom Caucus was one example of an advocacy group that started taking the law and then sending its interpretation to major law firms and making threats against law firms for health plan benefit announcements that they would cover travel to abortion permissive states. So the real aggressive activity is not necessarily happening in government or regulatory offices in hostile states, but it's all of these newly empowered third-party stakeholders who really clearly are very activated on this issue, and these are very real threats. I mean, other potential consequences of disclosure of highly sensitive data, right? Reputational damage, humiliation. We've seen this issue actually coming up. Providers having patients find out about disclosures of their information and coming to them very upset about it. Religious persecution, right? You can also geolocate people's visit to religious institutions, employer interest and potential ramifications at work, personal life issues, discrimination. As I mentioned, employers, insurers, housing, lots of questions out there where this digital footprint that's being developed really has compromising information that's causing many people to reevaluate how well their health privacy is protected and what they need to do to be more protected.
Definitely.
So we wanted to say a little bit about what's next. What other sensitive information could be the culprit of unfair and deceptive practices?
So we've already seen the FTC go after period tracking and reproductive rights information that's being shared, disclosed by these direct-to-consumer companies. We're honestly predicting that female contraception might be next. That information is also extremely highly sensitive and might be disclosed to, God knows who.
Right. And just two quick comments on this, right? We saw in the Fifth Circuit decision, the Fifth Circuit U.S. Court of Appeals decision in the Alliance for Hippocratic Medicine case that where it was challenging access to the one of the medications used in medication abortion, mifepristone, and they cited the Comstock Act, which is an 1890s federal law still on the books that that refers to you know, all kinds of lewd things and specifically targets contraception. So anyone who thought that these old laws that are just sort of hanging out there were not relevant anymore are waking up to it. And just to give you a practical, you know, give people a practical application of what's going on, we have gotten calls, not to pick on Texas, but we've gotten calls from Texas pharmacies and physicians who have said that they're nervous about prescribing contraception, right? Like the sort of the day after medications like Ella that are really a form of contraception that are not reached by abortion laws. There are still pharmacies now afraid to provide those medications. And this is clearly sort of an adjacent area that is the next up issue on health privacy.
Right. And the concern, of course, is regular consumers, let's say in the state of Texas, going on social media sites, going on the internet in general and typing in search terms like where can I find contraception, which pharmacy prescribes, etc. All that information is collected, tracked, and as we've seen clearly, it's being sold and shared without consumer consent, and that's where the concern comes into play. We wanted to talk about a little bit of kind of what we predict the future of FTC privacy enforcement will look like. Obviously, mobile health apps in general, digital therapeutics companies, and artificial intelligence is growing like crazy, growing like wildfire. The FTC hasn't really commented too much about artificial intelligence. They released a policy statement, I believe in November of 2022, so just a few months ago, about the collection of biometric data and how the FTC plans to use Section 5 of the FTC Act to kind of regulate it. Biometric data at this point can include anything like facial recognition software, fingerprints, handprints, identifiable images, even certain voice recordings that identify people. Their definition hasn't really extended to other kinds of, I'm calling it non-traditional biometric data, like stethoscope apps, for example, that we've seen pop up into the marketplace. We don't know how those are going to be regulated. There are all kinds of apps that are using artificial intelligence to evaluate recordings and images. We haven't seen any kind of FTC enforcement on that front.
Yeah, just a couple. I just want to make a couple points in terms of this information. By the way, I think it's huge questions about what's going to happen with AI. If anyone's used ChatGPT, you could theoretically go to ChatGPT and type in, I'm experiencing the following symptoms. Right. What could this be? Right? You can already do that more crudely through Google or other search engines. And so how AI reacts is going to be very important. One of the areas that's really interesting has been behavioral health AI apps, where if you are feeling lonely or depressed or dealing with an issue, you can actually interact, and you think you're interacting with a person, but really you're interacting with a chatbot that is collecting data. And we still have not gotten clear answers of how that type of information being covered. So lots of new issues coming up around this. And regarding the point about biometric data, we are living in the time of the quantified self. I spent, true confessions, I spent 40 minutes on my Peloton this morning, and there's all kinds of data that Apple has in my watch, Peloton has, and we all are walking around with all this health data that could be interesting for people trying to figure out what our health risks are. So this is just a really an area that we're only on literally step one of with lots of questions still left to be answered.
Definitely.
So we want to talk about, by the way, another practical topic that is not getting enough attention. If you've been paying any attention in the last few months, there has been a wave of class actions based on all of the privacy issues that we're talking about. And this is really a very important unfolding story that really needs to get more attention from privacy lawyers and health privacy advocates in general. So we've seen literally in the last six months or so, we've seen a wave of cases, at least 30 cases against, they began with major healthcare systems, like some of the ones we've listed, and they've extended now into telehealth companies. BetterHelp also got one of these cases, and these cases are really piggybacking on the FTC. So there was a question that came up in the chat. Sorry, my eyes aren't that great. Do you think this FTA ruling will create responsibility and potential liability for medical device manufacturers? Right. I think the answer is absolutely. There's liability risk here for medical device manufacturers as well as for others. And I think the point here, by the way, that I would take away from this is that plaintiff class action lawyers are always looking for where's the next frontier. Well, guess what? Here's the next frontier. And even though these cases tend to start with the biggest institutions, that have the most sort of reputational concern and the most capital to settle cases for big dollars, these cases are flowing downstream. And so what I think we can tell from the targets that are being selected is these are the richest, sort of, if you will, the fattest targets out there to go after. But this is an area that's going to keep on giving. Just to give you an example of where we see this trend. Another unrelated to the topic of this webinar, Americans with Disabilities Act cases against websites for lack of access to the blind. If you look at where those cases, who was being sued 5 years ago, and who was being sued 3 years ago, and who was being sued this year, it's not like it ends. It's just, the plaintiff lawyers move downstream to go after new targets. But this is literally the front line, if you will, of health privacy risk. And medical device manufacturers, anybody who's out there engaging in any kind of consumer marketing is going to face these kind of cases. And by the way, what's being alleged in these cases? Well, they're different in different states, right? There's been what we're seeing is a growing pattern of different law firms filing slightly different cases. But in general, they're kind of throwing kitchen sink allegations in using federal laws, some that we would expect, HIPAA, Electronic Communications Privacy Act, ECPA, Stored Communications Act, right, as well as state laws. And they're going after all of the activities that evolved in using health data for consumer marketing purposes. Again, interception of data, collection of data, access, use, maintenance, disclosure. I share all those verbs only to say, like, there's a lot of ways in which organizations are touching health data that we don't even necessarily think about. So you might be an organization that's not trying to, leverage this data, but you might be collecting it also, and just sort of sitting on it. And the takeaway here is that, this issue of how you market is very much part of your health data privacy practices. My belief is that most organizations, HIPAA and health privacy compliance program plans aren't or have not historically included these issues. And the privacy policies often are not really squarely focused on these. And those are both areas that need attention. Your compliance program needs to change. Your privacy policy needs to change. This is not just a risk of who's going to be the FTC's next target, but it's a question of when plaintiff lawyers are going to get around and focus on the organizational setting that you're sitting in. So the last issue that we really wanted to highlight here is that we alluded earlier to the sort of what the FTC is trying to do. And ultimately, the goal here is a culture change. And the reason we're sharing this is to say that it's not just about, the minimum necessary compliance with the law. Really, the critical thing that any organization that wants to be growing and healthy and strategic needs to do is to figure out where are we moving to? Because we are clearly in a period where the requirements, the norms, the enforcement are changing, and where should you be directing to? So first of all, it's very important for anyone who's in the mobile health app world to know that the FTC came out with its own guidance last year, at the end of last year. And this was intended to be a sort of set of best practices, which, by the way, the FTC also published. Not a guarantee that you're in compliance if you can answer all their questions correctly, but really a framework to analyze what your obligations are, not just under the FTCA, but also under HIPAA, under the Food, Drug, and Cosmetic Act, under COPPA, the Children's Online Privacy Protection Act, another privacy law that, again, people only began to pay attention to after class actions. And they were asking important questions, right? Like, what is your app doing with regard to health information? Does it, is the information within the HIPAA definition of individually identifiable health information? Are there consumers needing prescriptions? Are consumers using it? What are you doing with the data? Who are you sending it to? And a lot of very important questions. So it's a great starting point for anyone doing mobile health, both online on a website or via an app. We also wanted to highlight the Better Business Bureau as just one organization that's really been out in front of creating a new framework for health privacy. And the value here, whether or not organizations want to seek the certification of the Better Business Bureau, I would encourage anybody who wants to think seriously to look at what kind of best practices are being pushed here, right? And the emphasis here is, we always talk about three compliance: transparency, accountability, and integrity, and applying that to this issue of limiting your collection of health data, your disclosure of it, your use of it. Another really important point of these frameworks is that all the cases we've talked about today are focusing on notice to consumers and consent, but really not only sort of scratching the surface of the ultimate issue of how you're actually using the data, right? That's kind of I would argue that's almost like an outdated modality of how we think about health data, like notifying people of what you're doing with the data, or notifying them, getting their consent is one method. But the core question, of course, is how is the data actually being used? And then again, covering all sorts of information that anyone can use to make an inference or a judgment about someone's health or mental health, and covering all these non-HIPAA entities. So really worthwhile to look at. And just on the next slide, we wanted to sort of talk about what does that future framework look like? Like, where are we moving to? And I think this is a great place to look. Really, if you look at that list of 13 principles on the right side of the page, there's a whole bunch of issues that were never part of the discussion when HIPAA was enacted or when the FTC Act was enacted, right? AI considerations, I'm pretty sure, was not something that we were talking about back then. And so a lot of questions, consumer right to data, whole new topic of how our system is moving to a consumer-centric one. And these are issues that are really not fully addressed by the current laws, and that really organizations that want to be ahead of the curve and really protecting themselves maximally and thinking strategically should really be focusing not on just what do we need to do to stay out of the crosshairs, but where should we be moving? And so this is just one great example. So finally, we wanted to just say a little bit about what we should expect next from the FTC. Okay, so we talked about culture change. That's really what's at stake. We've seen, as we mentioned, this first step on reproductive health based on the anticipated and then eventual repeal of Roe v. Wade, a move to behavioral health that we've already seen with like the BetterHelp example. And the next frontier is undoubtedly genomic information, which is we haven't even really talked about today, but is really like a treasure trove. You want to know someone's anticipated cancer risks and all kinds of patterns about their future health. We're on literally at the beginning of that revolution, and that is clearly a place that we expect the FTC to go. We expect the FTC to be spending much more resource on consumer enforcement ahead. I would say that these cases have been working at sort of calling industry attention and public attention to a gap in our system. And we expect, when something's working, we're gonna see more of it. So more of that from the FTC. We expect to see advocates pushing for greater enforcement power ahead. And one of the big questions is whether there's going to be bipartisan consensus on health privacy or polarization. Very interesting to note that that we've been seeing a few examples now of bipartisan letters to the FTC from various legislators asking for more attention, because big tech worries both people on both sides of the aisle. On the other hand, as we talked about, the abortion issue is divisive, and it's very interesting to wonder what the FTC's enforcement will look like the next time that there's a change in the party in the White House and in Congress. So really big questions ahead that we think are gripping and should be and important, and we hope you are focused on too.
Definitely. Thank you so much for joining us. We hope the information we presented today was interesting, intriguing, gave you some food for thought, maybe something to look into further. But we're not done yet. We have 2 more webinars coming up. We've been focusing on federal law for a while now. Next month, when you join us, we'll be focusing heavily on state actions and how states are trying to fill the gap in healthcare privacy. And in August, for our final webinar, to predict the future, I guess.
Thank you so much for joining us. We encourage, if you haven't had a chance to watch our earlier episodes in this series, we encourage you to do so. Really is a whole new world of health privacy, and we hope that today's presentation gave you a flavor for that.
Definitely. Thank you very much. You can contact us here. Both of our emails are available here. We're available on LinkedIn as well, and look forward to seeing you next month. Thank you.